The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. I'm Amy Quackenboss, the Executive Director of the American Bankruptcy Institute. I'm pleased to welcome you to the next webinar in our ABI Live series. Today's webinar is hosted by ABI's Commercial Fraud Committee and is entitled Pursuing and Proving Fraud When Individual Debtors Hide Their Business Assets. Our panel of experts will discuss issues related to hidden assets from the perspective of both the trustee and the debtor. Before we kick off the webinar, I'd like to address a couple of housekeeping matters. If you need CLE, please make sure you are recording the CLE codes that will appear on your screen throughout the program. Also, during the webinar, if you have questions for the panelists, please type them in the GoToWebinar conversation box on the right of your screen. These questions will be sent directly to our panelists. I am now pleased to introduce Adam Crane from HSM in Grand Cayman. Adam is the Special Project Leader for ABI's Commercial Fraud Committee and will be introducing our webinar today. Thank you, Adam, for your work on planning the webinar, and I will turn it over to you.
Thank you very much, Amy, and congratulations on your appointment as Executive Director of the ABI.
Thank you.
As Amy indicated, my name is Adam Crane. I am a cross-border insolvency and commercial litigation attorney in the Cayman Islands at HSM Chambers. I am the Special Projects Leader for the Commercial Fraud Committee, and today we have an excellent program for you. And I want to thank everyone who has helped out with putting this webinar together at the ABI, and a big thank you to the speakers who worked extremely hard to bring this very interesting and informative session to our audience today. Also wanted to thank our members for participating and welcome any attendees on the phone that are not members of the Commercial Fraud Committee to please consider joining our group. And thank you as well to those who attended our reception at the Winter Leadership Conference in December. And looking into the future, the Commercial Fraud Committee is planning on hosting another webinar this spring with more to come down the road. If you have any topics you are interested in, or if you want to participate as a speaker, please do reach out to me. You can find my contact information on the ABI website. And finally, our committee is looking for authors to contribute articles to our future newsletters. If you are interested in submitting an article, please reach out to Michael Napoli. He's responsible for the articles. I understand that our latest newsletter will be out this week, and our next upcoming newsletter will be published in May 2020 with an article submission deadline of April 17th. Without further ado, I'm very pleased to introduce and turn this webinar over to our excellent moderator for today, Grace Robson. Grace is a partner with the law firm of Markowitz, Ringel, Trustee & Hartog in Fort Lauderdale. She is an expert in bankruptcy law and is a board-certified bankruptcy attorney with over 17 years of experience representing corporate debtors, trade and institutional creditors, trustees, receivers, and creditors committees. She focuses her practice on corporate reorganization and bankruptcy, debtor-creditor relations, and litigation. The stage is now yours, Grace.
Thank you, Adam. Welcome, everyone, to this webinar that we've been an honor to participate in. So I'm going to be the moderator. I'm going to first introduce my co-panelists, and I'll be doing this alphabetically. So I'll start with Scott Brown. Scott has been practicing in the bankruptcy insolvency field for almost 16 years. He concentrates his practice on fiduciary representation, creditors' rights, bankruptcy litigation, and business reorganization. Scott has been a Chapter 7 panel trustee since 2011 and has also served in a variety of other fiduciary roles, including as Chapter 11 trustee, examiner, receiver, and has also served as mediator in several matters. Mr. Brown is based out of Miami, Florida. Next, I'll turn to our panelist, Peter Davis. Peter is based out of Phoenix, Arizona, and has founded the firm called Simon Consulting in 2000 and has over 20 years of experience in complex forensic accounting matters, receiverships, fraud detection, bankruptcy matters, family law matters, business valuations, and commercial damage calculations. Mr. Davis is skilled at presenting complex information in both jury and bench trials and has provided expert testimony in numerous federal, bankruptcy, state court, and arbitration matters. He has taught forensic accounting and receiverships at Arizona State University and has provided training on fraud and forensic accounting to numerous organizations. Mr. Davis is a certified public accountant, accredited in business valuation, certified in financial forensics, a certified insolvency and restructuring advisor, a certified turnaround professional, and a certified fraud examiner. Obviously, he's very useful in many contexts in which we find ourselves as bankruptcy professionals. Okay, now last but not least is Joseph Wolobinski, based out of Dallas, Texas. I'm going to call him Joe. Joe is a shareholder in Winstead's Business Restructuring and Bankruptcy Group. For over 35 years, he has concentrated on bankruptcy, creditors' rights, and financial restructuring, and is active throughout the United States in several restructuring and insolvency matters, and related litigation. As part of his firm's fraud and asset recovery group, Joe has represented numerous victims in matters involving complex financial fraud, theft, money laundering, and other white-collar crimes. Joe has also served as a federal district court receiver for the Securities and Exchange Commission in cases involving cross-border fraud schemes. Joe is the executive director emeritus of ICC FraudNet, which is a London-based invitation-only network of lawyers throughout the world who have significant experience in complex commercial fraud and offshore asset recovery. Joe is a member of the International Bar Association, the International Association for Asset Recovery, and the American Bankruptcy Institute. So we are here to discuss how parties can identify or locate assets that were not disclosed by a bankrupt debtor, and how trustees and parties can work together to recover those assets. So while the vast majority of individual debtors are honest and simply need bankruptcy relief, some debtors are not. Fraud can arise in various contexts and in various degrees in bankruptcy. No set pattern or established set of facts exists, and each case is different and should be treated differently. There is no smoking gun in every case, and sometimes no smoking gun is ever found. And it's impossible to consider or evaluate every way debtors might hide assets. So our objective today is to focus our discussion on how to look at bankruptcy fraud holistically and give you some insights from the various perspectives of parties in a case, and identify and establish fraud when assets are hidden and obviously subsequently discovered. So I think a place that it makes sense to start with is from a trustee's perspective. And so in that framework, we're going to turn that over to Scott Brown.
Well, thank you, Grace, and thank you to the ABI for inviting me to participate, and for everyone who's attending. As set forth on slide 10, the duties of a trustee, as I think everyone probably knows, include, among other things, investigating the financial affairs of the debtor, collecting and reducing to money the property of the estate for which the trustee serves, closing the estate as expeditiously as is compatible with the best interests of the parties involved, and, if advisable, opposing the debtor's discharge. Turning to page 11, there are a variety of tools and powers available to the trustee that we'll be talking about throughout today's program. And some of those overlap with tools that are also available to creditors and secured creditors. Among those, as set forth on slide 11, is, and probably the most powerful, are avoidance powers of the trustee under sections 544, 547, 548, and 549 of the Bankruptcy Code. Pursuant to section 544, a trustee can use state law to bring in state law causes of action, where in many cases there are states that extend the look-back period from, say, the 4-year 548 period, the 2-year 548 period to 4 or even 6 years, depending upon the state. It's also important to note, and we'll talk about it a little bit later, that there is a line of fairly recent case law that holds that trustees can have a 10-year look-back period if the IRS, known as a golden creditor, exists as a creditor on the petition date. So that's a very powerful tool. Trustees also have the ability to conduct 2004 examinations of the debtor and third parties, the ability to freeze bank accounts, And this is a very powerful tool that I've had great success with. There are a number of banks, particularly Wells Fargo today, that automatically notify a trustee almost instantaneously, within 24 hours of a bankruptcy petition being filed, of the existence of bank accounts in the name of the debtor. Wells Fargo, I think Bank of America is starting to do it now, but Wells Fargo is the leader and is on the forefront of that, and actually maintains a national database. And immediately upon being notified via constant PACER, by reviewing PACER on a constant basis, they actually freeze a debtor's bank accounts and give immediate notification to the trustee and to debtor's counsel. So quite often I'll find situations where a debtor did not list a bank account or several bank accounts, but lo and behold, I get a letter from Wells Fargo that there's 10 or 20, or I've had cases with over $100,000 frozen by Wells Fargo. Trustees also have the ability to intercept tax refunds and conduct home inspections either with or without notice, and if necessary, obtaining a court order, sometimes under seal if they believe that the debtors might remove property from their homes. Turning to slide 12, where do the trustees and creditors find information? And I think one of the important things to note today, obviously, debtors file petitions and schedules under penalty of perjury and bankruptcy fraud. And as Grace said, the overwhelming majority of debtors are honest people deserving of a fresh start. But what we are here talking about today are debtors that are trying to, and in fact, hiding assets. And from a trustee's point of view, it is getting, I think, harder and harder for debtors to truly hide assets, simply because of the advent of technology and the tools that are available to trustees and creditors to find out information. So prior to a 341 meeting, I and most trustees I know, certainly here in the Southern District of Florida and nationwide, conduct background reports either using LexisNexis, TLO, Westlaw, Experian, etc., that pulls public records from a variety of databases. So it's pretty easy to see if a debtor has property, automobiles, airplanes, boats, things that are in that debtor's name in the public records. They're almost always going to show up on these background searches, which encompass the public records. Those same companies also are now offering social media type searches where we're able to take a look and see the social media of the debtors and see, for instance, the debtor might be wearing a Rolex or a diamond ring or some other jewelry or carrying luxury clothing or handbags or goods that are not disclosed. And of course, creditors, disgruntled spouses, employees, and partners are also excellent sources of information for a trustee. So with that, I think I'm going to turn it over to Joe, who's going to talk a little bit about the creditor perspective.
Oh, and before you do that, sorry, this is Grace again. So just wanted to speak to the audience and say, if you have questions, obviously feel free to please put them into the right-hand screen on the GoToWebinar screen, and we're going to try to save them till the end. So don't be discouraged if you put in a question and we haven't addressed it. We're going to try to address them later on in the Q&A portion of the program. Okay, Joe, so why don't you tell us a little bit from the creditor's perspective. I'm sure we can, agree that some of the tools that were identified by Scott can also be used by creditors, but are there some additional sources of information that a creditor may be able to assist a trustee or other creditors in an analysis of a debtor's assets?
Okay, thank you, Grace, and thanks, Scott, and also thanks to the ABI Fraud Committee. I think we all agree that information is key in any fraud investigation or litigation, and Scott did point out several good sources of bank information all of which is available to creditors. One thing, he mentioned 2004 exams, and both those and depositions, I think, are really great tools for uncovering additional information. In addition, it's your chance to hear the fraudster's story on the alleged fraud. They become locked into their story. And if there are lies, contradictions, or later corrections in testimony, that's very important to use to discredit their credibility. But also importantly, I think you always find additional sources of documents or information or witnesses that'll become invaluable. Now, while creditors and the trustee may have the same objectives to uncover fraud, the sources of the information do vary. I think if you look at slide 15, you'll see that secured creditors, we all know this, will require significant upfront information to make a loan. And that information flow will continue after the loan is made until the loan is paid. For example, updated financial statements or guarantees. So I think it's important that you look at the loan and collateral files for some of this important information. I've listed some of the information that you might find in those files. I particularly like the loan application forms because that's where the debtor may have stretched the truth in trying to get that loan. Also, there's third-party information like financials of guarantors that may be important, as guarantors usually have some connection with the debtor, and they may themselves be recipients of fraudulent transfers. Now, unsecured creditors may have less information available, but some vendors, particularly large, sophisticated vendors, may have some information in their files worth looking at. So that's always a source. Now, in addition to these standard forms of information recovery, I thought I'd mention some other means to access information that are less routine, but can be particularly helpful. And so if you'll go to the next slide. One of the things we all know is that technology is becoming more and more important, not only in our everyday lives, but also in fraud investigations. And I wanted to point out that there are some banking relationship search tools that you might want to be aware of. There's a company in Vancouver called Graylist Trace that's developed a program that allows you to determine if your target has banking relationships with any of the 250,000 banks worldwide. It doesn't give you actual account information. What it tells you is if there is a relationship with the bank or a high probability of a relationship. And that can be incredibly valuable, particularly when a debtor says, no, I don't have any relationship with any banks or only one or two banks in particular. Their service is not cheap, and admittedly, the company is new. I've not personally used it, but I have colleagues who have used it. And look, I'll give you a heads up. I think there's a question about, how far you can use it. Can it be used in court? But the company says that everything it does is legal. So I point that out to you. The other one would be private investigators. Not in your routine bankruptcy case. It's usually in a larger matter. But PIs have access to more robust databases, and they, of course, can do things like dumpster dive or conduct surveillance. I can tell you I had an experience where they actually, the PIs we retained followed a target because they learned that they were about to take an international flight. So they bought a ticket and jumped on the flight. And then they followed the person after and found that right after they landed in this foreign country, the first place they went was to meet with known criminals. Clearly, when you use a private investigator, you've got to make sure that they operate within the bounds of the law and make sure that the information they obtain is information that you can actually use in court. Another option, and again, in more serious fraud cases, particularly if you have strong evidence of fraud, I've asked courts to compel production from third parties, typically a bank. And in doing so, I was concerned about the bank disclosing my access to the information to the debtor, or having the bank disclose that, because I'm concerned about movement of funds. So in the right circumstances, I've made requests in federal court for information under a seal and ex parte, so the fraudster is not aware. And I've gone so far as to actually ask the court for a gag order on the bank to prevent them from telling anybody, particularly their customer, the fraudster. I mean, imagine how important that tool is if I can get access to the fraudster's bank account information and the bank can't tell its customers that I've subpoenaed them for that information. It's a strong tool. Another unique tool is 28 USC 1782. Once again, typically in larger frauds and ones that involve offshore or cross-border issues. I mean, it's little known, but it can be very effective. It basically allows you to go to the district court to get authorization to do discovery of documents and witnesses in the US in connection with litigation in a foreign country. There are cases in Florida where the courts have broadened the reach of 1782 to actually include contemplated litigation, not just actual litigation commenced. So, the slide 17 that's up there actually gives you the language of the statute. So those are the points I wanted to make, Grace.
Gotcha. Thank you very much, Joe. So I think we can all gather from Joe's discussion that there are a lot of practice pointers here. Look at the loan collection files or the loan application and the related files. Maybe you'll have to subpoena them from a lender if you are not the lender. Look at those third-party guarantees, and there are a lot of online and other search tools available to parties where it's warranted. So, the next perspective that we're going to want to take a look at is that of Peter's, which is the fraud examiner's perspective. So, Peter, can you help us out and tell me what you'd be looking for in analyzing a debtor's set of assets?
Yes, thanks, Grace. For reference, I'm on slide number 19. So when the fraud examiner gets involved, typically the creditor or trustee has discovered some red flags, or what we call predication for fraud, some sign or indicator that something's off, or there's some sign or indicator that there may be some hidden assets from the creditor or trustee. I think at that point in time, it's important to consider bringing in the expert. Even though you may not have all your discovery complete, you may still want to do depositions and issue subpoenas, but having the expert involved early helps to ensure that the discovery and the depositions include questions that will be valuable down the road when the expert may be issuing a report. It's also important for the expert to be cognizant of what documents they're relying on when they start to do analysis. We've had several cases where the underlying bank records turn out to be completely fraudulent. It's fairly easy using software such as Adobe Pro to go into a bank statement, a PDF bank statement file that the debtor may have on their server or on their computer, and manipulate that and adjust the payee amounts, the dates, and even the name of the payee. Also, we've identified that tax returns have been manipulated in many cases. To help validate this information, it's important that the bank statements are ultimately obtained directly from the financial institutions. But also tax returns can be directly obtained from the IRS, and now the IRS has an online access portal to obtain tax information. Also to consider is that Social Security Administration provides a history of earnings going back many, many years. So for purposes of an underlying individual debtor, that may be a useful tool to access. And perhaps one could get the assistance of the court, a court order, to enable the access to that information. Other things we want to consider are looking for non-market terms on promissory notes with related parties, trusts, irrevocable trusts in particular, offshore assets, children's trusts. With respect to offshore assets, where there's a credit card perhaps linked to an offshore bank account, and that credit card is being utilized to pay expenses of the underlying debtor. And then looking for other diversions of income. Flipping to slide number 20, some resources that we've used that have been helpful, as also mentioned earlier, Accurant and TLO are public records databases that allow for fairly inexpensively to do like an all-in-one asset search over an individual or a company. Now you get lots of stuff with that. You get phone numbers and address links, and then you get also, indicators of assets. That information must be validated back to the underlying county records, state records, and federal records that are available. What we use is a search service that, an online free service called blackbookonline.info. That website is a conglomerate of all the various state and county records, so that I can go to that one site to identify where my hits are. So if my hit is in a particular county in California, I can then go to Black Book Online, identify where that county, and then look at all the different resources that are available online for that particular county. In addition to these resources listed here, one can also access a website called archive.org. What Archive allows us to do is look back at a website and what it looked like historically over time. They actually have like a calendar service in there where you can go in and click at different dates and time to see changes made on websites. That can be useful to identify additional information. And one other thought I wanted to add, which is running a credit report on a debtor. Again, maybe that could be obtained through a court order or cooperation with the debtor. But a credit report could indicate debts, but debts that could be also linked to assets. And so in the search for assets, identifying those debts could lead to a potential asset. So what we try to do as a forensic accountant is utilize this information to tell a more accurate and defendable story ultimately before the trier of fact, to try to recover assets and bring resolution for the trustee and creditor in the recovery efforts.
So Peter, what I'm hearing is, number one, hire a forensic early, especially, I guess, if you know that the case is high profile and that there was some notoriety behind the person, which, will help certainly a trustee. Then someone like Scott, a panel trustee, would go in, or Joe, as a creditor's counsel, would have some background information, do some public searches, and then to compile your information to build a case or just do the investigation. Your recommendation is to subpoena, to the extent you can subpoena, bank records, credit card records, to make sure that you have the authentic version, right, from the records directly from the financial institution. And then to the extent it's something like IRS or Social Security Administration, you may need to compel the debtor to have those requested by the debtor, because I don't know that those government agencies may just give them to a creditor, but they may give it directly, at the debtor's direction to counsel for a trustee or, the fraud examiner. So with that, when you're getting prepared to prepare an expert report for a trustee or creditor, are there any standards that govern, how you prepare your report and how you do your investigation?
Yes, there are, and thanks for asking that, Grace. And by the way, your comments earlier, I agree 100% with. There's a subtle twist I was just going to add to what I spoke about, which is that sometimes these asset searches online don't discover assets because LLCs are created in districts like in Nevada, where they can be hidden under a statutory agent or an agency that basically shows up as the entity owner as opposed to the real owner. So for those situations, we may need to dig deeper and perhaps could discover that through other links, such as an address match or discovery through obtaining information from the sources where those assets were purchased. So for example, if a home was purchased or otherwise. So I just wanted to add that little nuance. But going back to the standards here that are in front of us, the AICPA recently issued standards for forensic accountants, and I'm referencing slide 22. This particular standard is also in the materials. It's a fairly short standard, but essentially it's required by the AICPA for CPAs to use practicing in this area. forensic accounting, or anything that really falls under this type of service. And it defines the obligations of a CPA, the standards, the ethical requirements that CPAs operate under, that we have to utilize professional competence, do professional care, we have to plan and supervise, and sufficient relevant data has to be utilized in our analysis. And these provide tools for attorneys to use potentially for cross-examination. I found some experts who are CPAs preparing reports not aware of these required standards. This particular standard just came into effect January 1st of 2020. So we want to make sure that the CPA, whether they're aware or not of it, but that use it for cross-examination. Of course, if they're your forensic accountant, you want to make them aware of it, but if you're on the other side of it, you want to use this as cross-examination. Specifically in the material, this standard, it prohibits the CPA from opining regarding the ultimate conclusion of fraud. And I thought that was helpful because, I have seen expert reports in the past where experts seem to get a little further along than they should, and this standard seems to help to restrain that. So again, this is attached in the materials and may be helpful.
I think, and this is Grace again, so yeah, thank you very much, Peter. I think that certainly I was not aware, that there were new standards established, and hopefully this will be helpful to those attending this program. So now that we've discussed a little bit about how to identify, potentially hidden assets, how to locate them, what is the, next step once we've discovered that there is something there? Scott, do you want to talk about, what a trustee or a creditor might do when you've discovered these kind of facts?
Absolutely. Thanks very much, Grace. As I briefly mentioned earlier in the program, probably the most powerful tool of a trustee is the ability to bring an avoidance action, be it a fraudulent transfer under bankruptcy or state law, or a preferential transfer under bankruptcy or state law, using 547, 548, or Section 544 of the Bankruptcy Code, because generally only a trustee has the standing to bring those actions. And certainly those are very, very powerful tools with significant look-back periods, both under the Bankruptcy Code and under state law. And as I think Joe will talk about in a little bit, one of the a not uncommon scenario, particularly when you have what we'll call a bad debtor that has been committing fraud or alleged to have committed fraud, and has really one major creditor that has pushed the debtor into bankruptcy, is the trustee often teaming up with that secured creditor or the large creditor, even if there's no money in the bankruptcy estate, by bringing in that creditor's counsel as special counsel, which is a powerful tool and allows the trustee and the creditor to pursue that debtor, notwithstanding the fact that the debtor has filed for bankruptcy. Other tools and potential causes of action that can be brought include substantive consolidation or subcon of business entities with an individual debtor. And there are some cases in the materials that are included with the presentation. One out of South Florida that I participated in, Capilla v. S&G, and in that case we were able to substantively consolidate non-debtor entities into the debtor's estate. And as you'll see from the supplementary materials, the ability to substantively consolidate non-debtor entities with a debtor estate would be a power that a bankruptcy court would exercise under Section 105. And there is a split of authority depending upon the jurisdiction you're in on whether a bankruptcy court believes that it has the power to do that. But nonetheless, substantive consolidation, assuming that it's permissible in your jurisdiction and assuming that you meet the East Group factors, is certainly another very, very powerful tool that can be used. There are complaints under state law to provide for alter ego and nominee theories, and a trustee can always bring objection to a debtor's claimed exemptions and a complaint objecting to the debtor's discharge, provided that the debtor has done something violative of the enumerated factors set forth in Section 727 of the Bankruptcy Code. And if that occurs,
hiding. Oh, sorry, Scott. So just hiding assets, that would be a basis to object to a debtor's discharge. So
absolutely. Failure to hiding assets, failure to keep or preserve recorded books and records, transferring assets with the intent to hinder, delay, and defraud creditors within a year of the bankruptcy, and a variety of other enumerated factors in 727. And of course, that is the worst of all worlds for a debtor, because the debtor then loses the discharge, assuming the trustee or creditor, who would also have standing to bring 727 action, is successful. The debtor would be denied his or her discharge, yet the trustee would have the right to continue to go about monetizing, investigating, collecting, marshaling, monetizing assets for the benefit of creditors. So that's very powerful. And then lastly, on subpoint F would be a complaint to determine dischargeability of debt. That would be under Section 523 of the Bankruptcy Code, and that would certainly be something that a creditor rather than a trustee would bring. And I think I'll turn it over to Joe to discuss that. Joe?
Yeah, thank you, Scott. A couple of points on this. Not included on the list should be other state law causes of action that may be relevant to the alleged fraud. I mean, it's not unusual to sue somebody for a fraudulent conveyance where you also include causes of action under TUFTA, the local fraudulent conveyance statute, or just claims for fraud, theft, conversion, breach of fiduciary duty, and aiding and abetting, among others. Of course, the issue you may run into if the litigation is in the bankruptcy court is bankruptcy court jurisdiction. So I think you have to be mindful of bringing these additional claims. With respect to objection to discharge or dischargeability, I have used them before, but they're typically not on the top of my list. I might use them for leverage, as it's important the debtor realizes that there's a risk that they could lose their discharge or dischargeability of a particular debt. But while they may provide leverage, in my mind, they don't return money. And so I usually am looking for other ways to actually bring an action that results in the recovery of money. And as Scott pointed out, I do think in these situations, particularly the sophisticated debtor that happens to have good counsel and a big war chest, or at least the willingness to fight, bringing in or developing a situation where the trustee brings you in as special counsel if you're representing a creditor and your creditor agrees to fund the litigation. As Scott said, it can be very effective. You certainly develop a strong team. And look, these cases are not cheap. So, a trustee that's got no assets at the present time needs somebody that can fund the litigation, bring in people like Peter, for example. And so this can be an effective way to try to pursue and recover fraudulently transferred assets. Right?
Right. And thank you very much, Joe. And just as a practice pointer, one of the strategies that Joe just mentioned was, whether to bring as a creditor a complaint objecting to discharge, which is something typically a bankruptcy trustee would do. And sometimes in my mind, it's better to let the debtor get a discharge of all of the other debts, but your debt would not be discharged, and therefore you're the only remaining creditor with leverage and the ability to collect after the debtor gets a discharge. So there's no more race to post-petition assets. So that's just another thing, to keep in mind for purposes of strategizing with your client who may be a creditor, maybe a debtor, on the ability for these causes of actions to how it plays out in a case. So as we all know, there's two sides of a story, or some may say three, black, white, and gray. And so one of the things we want to also discuss today are defenses that a debtor can raise. Now, the seminar and the timing of which, obviously, we're not going to be able to get in depth on any one particular defense, because that could probably be a program in itself. So just a couple of things that I wanted to talk about were issues that arise with some nuances. So solvency, property of the estate, and exemptions. So if we go to the slide that we're on right now. So one thing a trustee or creditor has to be mindful of is the solvency or insolvency of a debtor at the time of any transaction. So insolvent is defined in the bankruptcy code with respect to an individual is their financial condition such that the sum of such entity's debts is greater than all of such entity's property at a fair valuation, exclusive of property that's transferred, concealed, or removed with the intent to hinder, delay, or defraud such entity's creditors, and property that may be exempted from property of the estate. So, what does that mean? There are different terms within the definition, which is found in section 10132 of the bankruptcy code for example, fair valuation is not a defined term. So you'd have to look at how the case law interprets that. So as well as likewise, it doesn't determine liabilities, and it's often the case that when you look at this, what's called a balance sheet test under the bankruptcy code, you have to deal with both contingent liabilities as well as the fair valuation of the assets. So in dealing with contingent liabilities, there's a generally accepted methodology for valuing such contingent liabilities, a typical one being pending litigation that has not been reduced to judgment, that requires that the contingent liability has to be discounted by the probability of the contingencies becoming non-contingent. So that's in the Blair case that's up on screen at the moment. As to contingent costs that are part of the contingent liabilities, those debts must be limited to the costs arising from foreseeable events that might occur while the debtor remains a going concern. And that's discussed in the Trans World Airlines case, which may be on the next slide. So in addition to dealing with these contingent liabilities, you have to look at the fair valuation of assets. And according to the Third Circuit, cases generally look at the market value rather than a distressed value, but also caution that the valuation must be analyzed in a realistic framework, considering amounts that may be realized in a reasonable time. And that's the Trans World Airline case. There's discussion there about that. In that case, the Third Circuit held that the reasonable time should be an estimate of time that a typical creditor would find optimal. So not so short a period that the value of the goods is substantially impaired via a forced sale, but not so long a time that a typical creditor would receive less satisfaction of its claim as a result of the time value of money and typical business needs by waiting for the possibility of a higher price. So in the TWA case, the Third Circuit upheld the bankruptcy court's determination that 12 to 18 months was a reasonable time to value the company's assets, because the span of time reflected the period in which a diligent administrator concerned with the interests of the creditors could inventory, prepare, and sell the assets in a reasonable time. Now, as I said earlier, as to the contingent costs, what the TWA court agreed to exclude for purposes of a contingent liability were the wind down expenses, severance payments, and other liabilities included in the calculation of insolvency. So in considering the solvency or insolvency framework, I also want to note that you only need to prove insolvency when you're dealing with constructive fraud versus actual fraud. So if you're able to prove that a debtor transferred assets with the actual intent to hinder, delay, or defraud, which can be done by circumstantial evidence, you don't have to prove the insolvency. But here, what we're talking about when you're proving insolvency is the constructive fraud, where there's less than reasonably equivalent value given for an asset. So the presumption, there may be a presumption of insolvency that you may be able to benefit from. So under the Uniform Fraudulent Transfer Act, which has been renamed the Uniform Voidable Transaction Act, at least in the 22 states that have enacted it, 3 of which are pending, none of which are the states in which Scott, Peter, or Joe practice in. So we're still going under the Uniform Fraudulent Transfer Act. But in some states and under the statute, you may be able to benefit from the presumption of insolvency. So in addition, when looking at a individual debtor and working on constructive fraud, insolvency cannot be proven by the fact that a debtor contemplated bankruptcy for a period of time before filing, and you can't make an inference that just because the person believed they were insolvent that they actually were insolvent. So just wanted to raise that point as well. Okay, so the next potential source of a defense for a debtor is an exemption. So one common exemption is called tenancy by the entirety, which is recognized in certain states, maybe not all states, but at least in Florida, there is a protection of assets that are held in this tenancy by the entirety if all of the unities are met, and the assets that are protected are, for example, if a debtor files and has a non-filing spouse, the assets owned jointly would be protected from creditors of the debtor if the non-debtor spouse was not also jointly liable. So the 6 unities are listed on the screen on the slide: possession, interest, title, time, survivorship, and marriage. And if any one of these unities is absent, the status of tenancy by the entirety is also not going to be there. So that's also important for people to look at individuals when they're claiming such an exemption. You want to get the source documents for title, get a deposition about the time, the marriage. I did have a case many years ago where usually the marriage element is not typically challenged, but it ended up that the debtor thought he was divorced, and then, or his current wife was divorced at the time that they got married, but it turned out they weren't. So that caused a huge problem for them in that case. So another issue dealing with exempt assets is tracing those exempt funds. As a general rule, commingled funds that are traceable to exempt assets retain their exempt status. So cases have dealt with tax refunds, retirement funds, annuity, workers' compensation benefits that are then commingled with non-exempt monies. And so courts undertake a equitable analysis or tracing to determine what portion of those proceeds should be protected. And I'm gonna, there's a list on the screen right now of the different methodologies that courts use, and I'll give the lawyer answer, which is there's not one test that's uniformly used. The courts are gonna apply the test that makes the most sense under the circumstances, so make your best argument for the test that benefits your constituency. And the courts are to use the test based upon, so that there are no inequitable results. So the most commonly used test that I could find in doing the research is the lowest intermediate balance test, pursuant to which you assume that the debtor withdrew the entirety of the non-exempt portion from the bank account, leaving the exempt portion as of the petition date, which may be a little bit confusing, but it's only if the funds go lower than the historical balance of the exempt portion. One nuanced methodology I'm going to ask Peter to help me out on is direct tracing, which he's had some experience with. Peter, can you help me out with that?
Thanks, Grace. Yeah, first, just taking a quick step back on tracing. The first step is really having a summary of all of the financial activity from inception of the account until the date of bankruptcy, and being able to look at the factual study of what was actually happening. Some accounts have a lot of ins and a lot of outs. Some have very little. Some have one or the other. You could have where much of the money has been spent, or where actually the balance has increased over time. So understanding the factual history is very important. The way we do that is we'll do a summary of all the bank statements day by day as every transaction happens in like an Excel database. We'll create columns over to the right, where then we'll allocate and document where the source of every deposit was from. We'll also document the outflows and where they're going in order to tell the overall story here. And then we'll create some columns that will document essentially what is exempt, and non-exempt, and create balances going forward. And so that's what I reference as direct tracing, which is the method that I use for showing and demonstrating the underlying effort to uncommingle those assets. The allocation between exempt and debtor assets, or if there's a creditor column that has to be created in certain cases, becomes a question that there is some subjectivity to it. Often the facts help us determine the appropriate method. The lowest intermediate balance test is most frequently used and comes up a lot in these individual bankruptcy cases. But depending on the facts, it may be something that the forensic accountant would want to explore an alternative for the court and offer the court an alternative that may be more useful. But ultimately, it would be a decision of the court on the appropriate method.
Right. Thank you very much. I appreciate that. So, okay, so one other category, I guess, of a defense that a debtor may raise to a transfer or saying that an asset should stay with the debtor is that the asset is not property of the estate. So property of the estate includes all legal or equitable interests of the debtor in property as of the commencement of the case, and that definition is in section 541 of the Bankruptcy Code. However, property of the estate in which the debtor holds only legal title and not an equitable interest becomes property of the estate only to the extent of such legal title and not to the extent of any equitable interest in such property that the debtor does not hold, and that's in section 541C. So what does that mean? So legal title versus equitable title. So if a debtor has legal title to a vehicle, however, the testimony is that the debtor gave his credit to a sister, and the sister is the one that really uses the vehicle. The sister pays for the vehicle, the monthly payments on it, and the sister pays for the insurance, and the debtor does not use the vehicle for his own purposes. Then that's a situation where the legal title may be with the debtor and ultimately equitable title is with the sister. So a lot of times when we analyze these issues, we have to remember to go back to the basics and, look at what the asset is and look at how it's being used, what it is to determine, is it an asset that's recoverable in the first instance. Likewise, assets that are held in trust can or may be protected. So if we go to the next slide, so under section 548E of the Bankruptcy Code, a trustee can avoid a transfer of an interest of the debtor in property that was made on or within 10 years, which is a long time. 10 years is a long time before the date of the filing of the petition if the transfer was made to a self-settled trust or similar device. Transfer was by the debtor, the beneficiary of this trust, the debtor was the beneficiary of the trust or the similar device, and the debtor made the transfer with the actual intent to hinder, delay, or defraud any entity to which the debtor became obligated on or after the date the transfer was made. So the Bankruptcy Code does not define what a self-settled trust or similar device is, but just please note that there are different kinds of trusts, and they're outlined on the slide that you're seeing in front of you. A revocable trust typically means the settlor, which normally is the debtor in our situation, retains the right to alter, amend, or revoke the trust during their lifetime. Therefore, it's typically considered an asset of anything in such a trust is considered an asset of the debtor. So there's no typically issue with reaching assets that may be in such a trust. An irrevocable trust, in theory, the settlor does not retain the right to alter, amend, revoke, or modify the trust. However, transfers to such a trust may be avoided if the trustee satisfies the requirements, under section 548E of the code. So practice pointer would be there. If the debtor is a settlor of any trust, you want to make sure to get a copy of the trust, get any information showing whether that trust was ever funded, and review the timing and all of the circumstances going into it so that you can make an analysis of whether there may be a viable claim to recover an asset that was put into that trust. So there's two other types of trusts that are listed there: spendthrift trusts, which are typically set up by a parent or somebody for a beneficiary just to receive some income, and typically if the language is done correctly, it would protect those proceeds from being reached by the creditors. Excuse me. So, and then lastly, there's reference to a qualified personal residence trust, and I would just say for this type of trust, it's a creation of a statute and IRS regulations, and there are very specific parameters, and so we're not going to get into all of that right now. Just know that this type of trust exists, and if one is purported to exist, please review the facts very carefully, because it may be that you know, a lot of times people don't comply with all of the requirements that would be needed to be maintained in order to keep that a protected asset. So,
hey, Grace, Grace, this is Joe. I just wanted to point out to the people listening in that on trust, we may not have time to cover the 3 cases that we've highlighted in our materials, but I would recommend you read the Blue Hippo Renson case, which involved an irrevocable trust established in one of my favorite jurisdictions, the Cook Islands, and the trustee's attempts to challenge that under Florida law. It's a very good case to just get a primer on these kinds of trusts.
Thanks, Joe. And this is Scott. The only comment I'll make on that, since that did take place in my jurisdiction, Judge Eric Kimball up in West Palm Beach, that was a very interesting case by the trustee in that case, who the self-settled trust was settled. It was an asset protection trust that was settled outside of the 10-year period. And there's been a couple of cases down here in South Florida where the trustee realizes that he or she cannot go after the self-settled trust under 548 because of the 10 years has passed. But if you look at the Renson decision and a couple of other decisions cited therein, Judge Kimball essentially held that foreign asset protection trusts are violative of public policy in Florida, and as a result, Florida law did not recognize that trust, and therefore the trust was nothing more than an alter ego of the debtor, property of the estate, and subject to administration by the trustee. And some of the things you need to look at in cases like that are how much dominion and control the settlor retained, whether the settlor has the right to unilaterally appoint new trustees, and a variety of other things. But it is a very, very interesting case, and I'm seeing more of these where folks think they have bulletproof self-settled asset protection trust. They've waited out the 10 years, but for a variety of legal reasons and theories, the trustee comes in and asserts that those trusts are nonetheless property of the estate. And again, because of timing issues, I won't go any further than that, but would commend you to certainly take a look at those.
Yes, thank you, Joe and Scott, for bringing that point up, as well as giving a preview of the type of case and the practice pointer, right, which is don't feel defeated if you see a trust and it's more than 10 years, because maybe in some circumstances it may be penetrable by some other legal theory. So with that, I'm going to turn to Peter to go over a case example of a matter that he was involved in a case where a bankruptcy attorney went rogue. Peter?
Yes, thanks, Grace. So in Arizona, we had a case involving an individual debtor who was also a bankruptcy attorney. Prior to filing bankruptcy, he had filed for divorce from his wife, and soon after the divorce filing, he created several LLCs in Nevada. And in Nevada, as I mentioned earlier, allows for the creation of an LLC that's hidden from public view. So asset searches and such that would perhaps be conducted within the divorce context or otherwise wouldn't, this entity wouldn't avail itself to those searches. He then began, he had a small law practice, and he began to take revenue from clients and deposit it into that LLC entity. And the LLC entity in Nevada opened a bank account, and the balance in that account began to grow significantly over time. And as that balance grew, he eventually used the LLC to acquire a luxury home in the Metro Phoenix area in Paradise Valley, actually, which is a very nice area. And the LLC acquired the home and then subsequently transferred that home to him. Now, prior to the home being transferred to him and such, he had filed bankruptcy, as I mentioned earlier, and did not put on his statements and schedules the ownership or the effective ownership of this LLC. So he kept it concealed, not just from his soon-to-be ex-wife at the time, but also from the bankruptcy court. And that was ultimately his demise, because ex-wife eventually discovered that he was living in this other home and informed the trustee, who then began an investigation and hired me, and we traced the assets. And here the real link, and what was very interesting, was that the agent that created the LLC in Nevada, when we subpoenaed those records from the agent to actually pinpoint the underlying ownership of the LLC to this particular attorney, it was a handwritten ledger in which the ownership and the underlying ownership by this individual attorney was shown in this handwritten ledger. And then every time a new corporate document was filed or a new corporate action was taken, it was recorded in this handwritten ledger, which we eventually had a copy of. But I also wanted to point out that subpoenas were issued to the title company and escrow company for the home, and there we saw the checks going from the Nevada LLC to the escrow company for purchase of this home, which was another link back to essentially his ownership of this property. In cases where you don't have the cooperation of an ex-spouse, which is really extraordinary at times, it's not every case you're going to have that. Just giving some thought to this as I was contemplating how we would go about helping to discover this type of asset, I would turn to these resources we mentioned earlier, such as TLO, because when we do these TLO searches, they include in there a list of addresses that the debtors used over time. And it may be useful, and what we do, in fact, is look at each of those properties and then look at the ownership here. And I think it would be important here to be curious about the entity which held the property in which he was living prior to it being actually transferred to him several years later. But looking at that property, that LLC, and seeing it's connected to Nevada, and then perhaps on instinct or otherwise making a request of the title company based on that, or inquiring further through a 2004 exam and evaluating that. Another thought would be to evaluate the income from the law practice, which would be an asset of this individual debtor, and perhaps to identify the decline in income, or to investigate the accounts receivable, because here they would, on the law firm accounting books, have to write off an accounts receivable as non-collectible because it's been collected in a different company, and then look for that increase in write-offs and try to understand why or how that was happening, and perhaps get the help of the accountant within the law firm. But these other suggestions are all a bit more difficult and involved, and in this particular case, we were fortunate to have the help of the ex-wife, which made it much easier to get to the bottom of this.
Yeah, thank you, Peter. Actually, one of the questions that we received was, since most experienced fraudsters are desperate business people who know how to use LLCs or multiple LLCs and shell companies to park their assets, how do you investigate for that? So if you don't have that ex-spouse, what do you think is your best way to, try to follow a breadcrumb, or what are the breadcrumbs that you would follow? And I'll invite, Joe or Scott or Peter to give a response to that question.
Peter. Go ahead, Scott. I'm sorry.
I don't know. I'll say very quickly, if in my case, the trustee, if I have information from what I believe to be, a credible source that there might be hidden assets, the logical next step would be to ask the debtor about them under penalty of perjury and bankruptcy fraud in either the 341 context, if the creditor has reached out to me pre-341, or during the 2004 exam, because obviously, if the debtor is truly a fraudster and is going to lie about it, then you're now, if and when you're able to prove the existence of that undisclosed asset, the debtor's problems are now going to increase exponentially because he or she is going to have committed fraud and perjury. So I think, getting the debtor on the record early, particularly at the 341 meeting, and locking in that debtor to answer under penalty of perjury and bankruptcy fraud whether they've disclosed all their assets, and all of the variety of other questions is the first step in that process. Peter, I think you wanted to jump in.
Yeah, thanks, Scott. I was going to just say that it depends on the facts. And I don't like the answer because there isn't one solution for this situation. The facts drive the case and drive the methodology in which the fraud would be unwound. But the things we've talked about here, a combination of looking at truthful records that are validated, from subpoenas and such. So don't get into the fraud yourself by relying on fraudulently manipulated records. So making sure that you're looking at the truthful records, whether it's financial statements, bank statements, tax returns, et cetera, it's important to know what we're looking at before we draw a conclusion. But then linking those records back to public record information, because that can tell us more holistically of the story. And then going back to counsel and having them request additional information. A couple of things I keep in mind that a fraud investigation is like peeling an onion. We're going layer after layer. As we get closer to the truth of the matter of what really happened. Having the budget and the folks who are angry enough about it, and incentivized enough, such as trustees and creditors, willing to spend funds on an incremental basis. And what I mean by that is they're not putting out, hopefully, a lot of money up front, but as you discover more and peel back more layers of the onion, it becomes more clear what happened, and then the value proposition, which is what can we recover here versus the cost, becomes more apparent and more clear. So working in a careful, phased or incremental approach helps. And I was going to add just one other thing, and that is I learned this a long time ago, but to catch a thief, we have to think like a thief. So in a sense, we have to look at the situation and put ourselves in the debtor's position to say, what would we do given the position that this particular debtor was in? What controlled it? What accounts did they have control over? What relationship did they have with particular trusts, LLCs, or individuals involved? And what would be possible there? And then based on that, using all the facts and information we have, which is never going to be complete, then using our intuition to then guide us a little bit to probe in additional areas and request additional documents and information. And I found oftentimes that is a tool for discovering, the fraud or additional frauds that happened in a particular situation. So I hope that's helpful.
And so, thank you. There was another question. So if a CPA cannot opine that there was any fraud, which I think, Peter, you said under the guidelines, you guys can't give that opinion, correct?
Correct.
Okay. So, Joe, maybe I'll direct this to you first. Is there any other expert that you can try to introduce to the bankruptcy court to give that opinion if it can't be a certified fraud examiner or a forensic accountant?
Well, look, I don't think that they can make the conclusion. I think what you do is you present a strong enough case on all of the elements to have the judge reach the obvious conclusion: fraud occurred.
Right.
I think that may be the most effective way to do that. Are there other experts that you could bring in? I guess you could bring in other third parties that are willing, non-professional, non-CPAs that are willing to say they believed a fraud occurred. the banker, the other witnesses that might be involved in the case.
Okay.
I mean, I think Joe is entirely right, because the judge, at least in bankruptcy, generally absent the once-in-a-lifetime jury trial in bankruptcy court, is the ultimate trier of fact. And, there are badges of fraud, and they're discussed in some of the supplementary materials. And while you may not have an expert that's able to opine that fraud occurred, if you show the judge enough badges of fraud, the judge is going to reach that logical conclusion. Sorry, Grace, I think I cut you off.
No, that's okay. Actually, my last question, one of the last questions is for you, which is, since trustees are only paid $60 per case, how cost effective is it to do all the background searches that you guys performed? So I don't know if everybody's aware that trustees only get $60 per case, and that just presumes it's a no asset case, but that's a whole separate discussion, right, Scott? So how do you, is it cost effective for you to run, whatever online search regarding a debtor?
Yes, thank you, Grace. Yes, it is generally cost effective when we're talking about that initial LexisNexis, TLO, Accurate, Westlaw report. The pricing is become increasingly affordable, and the prices have come down significantly. And those reports can be run for $10, $15 a piece, sometimes even less, depending on the number of reports you're running a month, if you have an unlimited service like I do. The other thing I'll mention just really briefly is that all panel trustees use one of 4 or 5 approved software vendors, and those software vendors are becoming, it's a competitive field. They want you to use their software, and they're developing more and more technology, employing and deploying artificial intelligence to identify the likelihood that any particular case is an asset case based upon the parameters that their artificial intelligence uses. So in a 341 meeting where I might have 30 cases, I will get a score from my trustee software company that suggests the likelihood that each case might or might not be an asset case and why. So those are all things that are not do not cost anything for a trustee for using those services, and they're becoming increasingly efficient and good at predicting asset cases.
No, that's great. Thank you very much. Okay, so one other question, 2 questions, but one regarding these credit freezes. We had a question from someone who said, have you ever encountered problems with credit freezes? I guess that's directed to Joe, because the question deals with, there was, I guess, a debtor put a freeze on their own credit, and a private investigator had trouble tracking someone who did that. So Joe, have you ever had a private investigator say to you, this person put a freeze on their own credit, so I can't, find anything?
No, thank goodness. I've not had that situation.
Okay, good. And then lastly, the last question, and I think this is a good roundup for this panel, which is, can we please have the citation for the Cook Island Trust case, which is the Blue Hippo case? And I believe it should be in the handouts, and if it's not, we'll make sure that the ABI circulates that to the attendees for the program. So thank you all for attending.
That case is Inri Rensin, R-E-N-S-I-N, out of the Southern District of Florida, West Palm Beach, Judge Kimball. And while you're wrapping up, I'll look for that site.
And I have 2019 Westlaw 2004000.
Okay, thank you very much, Scott and Joe. So now I'm going to turn it back to Adam Crane to complete the presentation.
Thanks, Grace. Once again, I want to thank everyone very much for attending our webinar today, and a huge thank you to the panelists. It was a great panel discussion today. And one final note, this is from the ABI. Please be on the lookout for an email from the ABI regarding information on how to obtain your CLE credits for today. That's all for us. Thanks again, everyone, for attending.
Have a great day.